Morning glory and evening grace, America. I'm Hugh Hewitt in Studio West of the Leaf Factor Studio out on the left coast. Boy, do I got a lot to cover with you, and I've got great guests coming up today to do that, including Senate Appropriations Chairwoman Senator Susan Collins of Maine in Hour 3 today. I've got Ro Khanna, a Democrat from the progressive wing of the party from California. Coming up this hour, I got Danny Pletka, I've got Catherine Boyle, I've got Charles C.W. Cook, Christine Rosen. I got so many people, and of course, Getting Hammered's own, Mary Catherine Hammered. But I need to start by just putting on my con law professor hat. I did this yesterday. I'll do it again today. Different classes, con law last night, and First and 14th Amendment today. President Trump built a trampoline in his first term. That trampoline is the Supreme Court. He added 3 justices who are originalists. Doesn't mean they agree. They often disagree, but they're all originalists. They are committed to the original public meaning of the text of the Constitution at the time it was adopted or of statutes in the same vein. Those originalists combine with Chief Justice Roberts, Justice Alito, and Justice Thomas to make up a 6-justice court that is generally, almost always, committed to the original vision of the Constitution, its amendments, and to statutes when they were drafted, the public meaning of it. And they sometimes disagree about that, but it's a framework. It's a way to go about things. The president has issued 2 executive orders that have drawn an extraordinary amount of scrutiny. I'll be talking about them throughout the day. First of all, birthright citizenship. I think President Trump has done a great favor to everyone born in this country of parents who are not here with permission. That is, illegal migrants, people who entered without legal migrant status, weren't invited, and who were born on U.S. soil, have long been considered by everyone to be citizens. But there's a small group of very, very smart academics and activists who believe that they are not citizens under the unusual wording of the 14th Amendment, reserving its application for everyone except those subject to the jurisdiction of another country. That was intended to cover diplomats and their children. So if the Court of St. James sent someone over here in 1871 or 1869 after the 14th Amendment, and that person had a child by the wife that he bought over with her, with him, that child would not be a U.S. citizen pursuant to the 14th Amendment. But what about the people who were born of parents in the country who were not citizens but were here legally? That was decided in 1898 in a case known as Wong Kim Ark. And it's pretty dispositive of almost everything, but let me review it for you. Mr. Wong Kim Ark was born of legal residents of San Francisco who were Chinese and subject to the then Emperor of China. And the parents went back to China after Wong Kim Ark was born, and Wong Kim Ark went to visit them in the 1890s. And upon return, was told by Immigration and Customs Enforcement of the 19th century, close of the 19th century, you can't come in under the Chinese Exclusion Act. You're not a citizen. Supreme Court got that case and said, oh, he's a citizen. His parents were here with permission. Wong Kim Ark, though, United States versus Wong Kim Ark, is not dispositive of the question of whether or not a child born to parents who are not here legally is a citizen. I believe that child is a citizen based upon the practice of the United States at the time of the 14th Amendment forward and the plain meaning and what it was intended to do. But some people don't. What Donald Trump did was to give a gift to all those children who are born in the United States of parents who are not here legally. A gift of a dispositive decision by an originalist Supreme Court. I believe at least 7 members, probably 9, will agree that anyone born in the United States is a citizen of the United States. That's what the executive order says isn't the case, and Donald Trump has served up. Now, why do I believe Trump is doing a favor? Because he told me 2 weeks ago he's open to the case for the Dreamers. He's open to that. And I'm all for, I just think his heart's in the right place on this. And so what he's done is he said to his hard right base and the activist, anti-immigration activists who are just absolutely convinced that birthright citizenship is not a thing, okay, I'll test it for you, but you're going to lose. I think he probably told them that you're going to lose. Second, more importantly, the executive order revoking Lyndon Johnson's 1965 executive order where we began to count by race. Quotas, which became goals, which became DEI, over a long and tortured history that I wish my friend Terry Eastland was alive. Terry wrote a book with Bill Bennett, my predecessor in the morning slot, before he was Secretary of Education, when he was down at the National Center for the Humanities in North Carolina. Terry Eastland was at the paper down in North Carolina, Greensboro paper, I believe, and they wrote a book called Counting by Race. And they laid out the case that the Bakke decision of 1978, in which Lewis Powell completely screwed up the law for the next 50 years, said, we ought to be allowed to let affirmative action work, but we're not going to have quotas. Hard quotas, no. So it was a goofy, terrible decision, and it launched 1,000 ships of idiocy. 1,000 ships of, let's, soft, hard, and it's not dead yet, even though the Roberts Court has done great good work. Chief Justice Roberts, in the 2007 case involving the Seattle School District No. 1, wrote, "The way to end discrimination based on race is to stop discriminating based on race." That's it. The United States does not award benefits or inflict penalties based on immutable characteristics. Your race doesn't matter. Your gender doesn't matter. Your ethnicity doesn't matter. Your country of origin does not matter if you are a citizen of the United States. You cannot do that. It's unconstitutional. But we have all the barnacles that have grown up from the 1964 Civil Rights Act. Now, we needed the 1964 Civil Rights Act because the Supreme Court screwed up back in Plessy v. Ferguson days. Again, at the end of the 19th century, it was racist. They said separate could be equal, which led to segregation, which led to bad schools for blacks and good schools for whites. And it took from, I think it's 1897, Plessy, until 1954 for the Supreme Court to say in Brown v. Board, separate but equal is not constitutional. Never was. 14th Amendment. There's a lot of history you don't want to hear about. Law students have to learn what happened in the slaughterhouse cases and what happened in the civil rights case. And they got to learn it all. But now all you need to know, this court has made it abundantly clear. It is unconstitutional to count by race, to count by ethnicity, to count by gender, to count by sexual orientation, to count by religion. Because that's what the Constitution says. This isn't a liberal. It isn't a conservative position. It's a constitutional position. And it's absolute, unless you want to amend the Constitution. So Trump, in this magnificent executive order, about which I wrote a column, it'll be in Fox tomorrow morning, 5 a.m. Eastern time. Long and short of it, it's a magnificent executive order. It is comprehensive. I don't know who wrote it for him. Donald Trump didn't write this. This took some good lawyering. And he's not a lawyer. He's a developer. And he's a president. And he's a force of nature. But he's not a lawyer. But he told his lawyer, I want this over. No more DEI. No more CRT. No more counting by race. No more goals and quotas. No more soft affirmative action or hard affirmative action. No more none of it. And this executive order is kind of long because especially, Johnson did his EO, which got quotas going in 1965. And then the court messed it up in 1978 with the Bakke decision. I had Archie Cox teaching me undergraduate con law. He was arguing the case that term, and all he ever did was talk about Bakke. And it's a mess. It's a hot mess of a decision. It's taken forever to dig out of that hole. It's like Ohio State University. Have I mentioned that they are the national champions? Well, they were in a hole after they lost to that team up north in November. And they climbed out of the hole by winning 4 in a row. And I mean, magnificent win. If you haven't listened to the Triple Option podcast ever, listen to it once. Mark Ingram, Rob Stone, and the Coach Urban Meyer, talking today about that win and what it meant and how Ryan Day is a hero. And he had been, he was at the bottom of the abyss with his players. They lost to that team up north. Don't want to do that. Wouldn't be prudent, especially not 4 times in a row. Ryan Day got a natty. Those young men got a natty. And you never take that away, forever. They're a national champion. First time they changed the format, Urban Meyer won the national championship. Second time they changed the format, Ryan Day won a national championship. They joined Jim Tressel and Woody Hayes, I guess Paul Brown, way back when. 5 great Ohio State coaches. But I digress. I'm just still happy about Monday night. I want you to go listen to Triple Option. Download it with Mark Ingram, Rob Stone, Urban Meyer. just to listen to Coach Meyer talk about what it means and what they did. And I want you to continue listening because I'm going to talk about these EOs with Ro Khanna. He's from the left. I'm going to talk about it with Christine Rosen. She's from the right. I'm going to talk about it with everyone because it's a big deal, a very big deal. It's a big win for the Constitution. Bravo, President Trump. I'll be right back. Don't go anywhere.